Welcome back to part 5 in the case review of Owens versus Lone Cactus Construction. This is our 5th and final part of what we have thus far in documents on this case. So let's jump right in. This one's going to be a shorter one. So here we have filed February 7th, 2022 in the Superior Court of the State of Arizona in and for the County of Maricopa, Owens v. Sean, the owner of Lone Cactus Construction, LLC. And this is the defendant's response to plaintiff's motion for summary judgment. So this is going to be Sean and Lone Cactus's response to that huge document that we had to break up. And they say it in very short ways instead of like 121 exhibits and like 180 pages and stuff. So, and this is assigned to the Honorable Judge Sarah Agnew. It says, come now, the defendant by and through their attorney, undersigned, and hereby respond to plaintiff's motion for summary judgment, as more fully set forth in the accompanying memorandum of points and authorities. And then we get to the memorandum of points and authorities. Rule 56, Arizona Rules of Civil Procedure states in relevant part. A. Motion for summary judgment or partial summary judgment. A party may move for summary judgment identifying each claim or defense of the part of each claim or defense on which summary judgment is sought. The court shall grant summary judgment if the moving party shows that there is no genuine dispute as to any material facts and the moving party is entitled to judgment as a matter of law. The court should state on the record the reasons for granting or denying the motion. Somehow we moved to C. I don't know what happened to B, but 3. Supporting and opposing statements of fact. A. Moving party's statement. The moving party must set forth in a statement separate from the supporting memorandum the specific facts relied on in support of the motion. The facts must be stated in concise numbered paragraphs. The statement must cite the specific part of the record where support for each fact may be found. Plaintiff's motion for summary judgment fails to sufficiently identify each claim or defense, or the part of each claim or defense on which summary judgment is sought. Plaintiff's motion fails to state the specific cause of action they seek summary judgment on, fails to set forth the specific facts relied on in support of each specific cause of action they seek summary judgment on. The plaintiff's motion fails to set forth the elements of each cause of action to provide legal analysis, including case law. Yeah, they did not bring any case law. It was just a story of what happened, basically. In addition to plaintiff's failure to properly format a motion for summary judgment, plaintiff's motion should be denied for the following additional reasons. Number 1, multiple triable issues on fact exist in this matter. 2, no foundation was provided for any of the plaintiff's voluminous exhibits. They were voluminous, in fact. 3, no affidavits were provided to lay the foundation and verify any of the 121 exhibits. A clear example of the triable issue of fact is demonstrated by the plaintiffs themselves. In their most recent pleading, their motion to compel and for sanctions filed Friday, February 4th, 2022, within plaintiff's pleading, they argue ad nauseum that the invoice attached to defendants' first supplemented disclosure statement dated and emailed to plaintiffs on Thursday, February 3rd, 2022, that the defendant has altered ARS 13-2002 A1 and presented ARS 13-2002 A2 and plans to use as evidence. This despite over the invoice goes directly to the core of plaintiff's case and creates tribal issue of fact as to the authenticity of the invoice. Interesting. We do know she likes to do arts and crafts. So did she fidget with these invoices or numbers, photos, and, documentation? Did she do that here? Because we know she's done it in other cases. It's very reasonable to wonder, where did this stuff come from? Is it legit? Plaintiffs attached 121 exhibits to their motion for summary judgment, consisting mainly of purported emails between the parties and others, as well as a number of photographs taken by an unknown person on an unknown date. Very true. We don't know the date that any of this was taken. We need to know where it came from. We need the metadata behind it. We need to be able to authenticate these pictures. Are they from when she says they're from, or are they not? Evidence submitted in support of a motion for summary judgment needs to be admissible evidence, not hearsay. Without an affidavit accompanying the motion for summary judgment, all 121 exhibits lack foundation and are hearsay. It is impossible to tell what counts plaintiffs are moving for summary judgment or partial summary judgment. Defendant, Lone Cactus Construction, LLC, is an Arizona state licensed and bonded contractor. Sean. Lone Cactus Construction, LLC is an active contractor with 0 open cases, disciplined cases, or resolved settled cases. Lone Cactus Construction, LLC holds a specialty dual CR14 fencing license. Lone Cactus Construction, LLC is bonded through Western Surety Company with bond number redacted. On or about December 2020, plaintiffs requested bids for steel fencing on their residential property located in Scottsdale, Arizona. The steel fencing was for horse corrals. Plaintiff, Owens, did not accept any bid from Lone Cactus Construction in writing on December 16, 2020. Defendant Sean did not meet with the plaintiff until February 16, 2021, at approximately 8 a.m. The plaintiffs did not arrive at the property until Monday, February 15th, as plaintiff stated in text messages. Defendant Sean walked the property with the plaintiff on February 16, 2021, and then sent the plaintiff an estimate on February 20th, 2021. So he went to look at the property, and then he gave her an estimate. Work commenced on or about Tuesday, March 16th, 2021. Okay. So she was wanting fencing, steel fencing for the corrals. I can see steel fencing taking maybe 4 days, no more than 4 days, and I can see the lower estimated cost for just fencing. I don't know if that was more. All right, so that's where we're at. And remember, the last one was hers, so we should believe her and be like, if this is what happened, that's messed up. Now we're with his, and now his is going to poke holes in some of that, so we should see this is where our minds might change. And so he said the work commenced on or about Tuesday, March 16, 2021. On or about March 16, 2021, a City of Scottsdale zoning inspector arrived at the property at approximately 8:30 a.m. and then left the residence. Defendant Sean called the city inspector and he returned to the property, stating that neighbors had concerns about construction projects. So the neighbor called. Nosy ass neighbors. Mind your business. The plaintiff informed Sean that they had posted project details on a social media site and figured that's how neighbors found out. So Owens was like, "Oh, we're getting this stuff done." And the neighbors follow them, I guess. Keep your business offline. I know that's hard. Defendant Sean then told the inspector that they were building fencing and stalls. So they're building stalls too, and asked what the non-permit criteria would be so that the plaintiff could have shading for their horses. The inspector then said 200 square feet or less, and that shade structures have to be 4 foot 6 inches apart from each other. After meeting with the inspector, all plans had changed. Okay, so in the beginning for like fencing, she didn't need a permit and things like that. Right now, it still looked like this is going to be a non-permit thing. And then now those plans that they originally had, they are changing. So it says at 12:24 p.m. on March 16, 2021, the same day, defendant Sean submitted a new invoice to plaintiffs who agreed to changes. And at 2:39 p.m., plaintiff texted defendant Sean that the deposit check was ready. Total price with changes totaled redacted. I hate that they redacted that because those numbers are important. On or about May 31st, 2021, plaintiff texts defendant Sean saying to hold off on coming tomorrow to work as we have questions about invoices. Okay. He is going to have to show that she sent this, or she told him this. On or about June 21st, 2021, Sean exchanged text messages with the plaintiff discussing settlement negotiations with the plaintiff as defendant Sean had been dealing with some unrelated personal issues. Plaintiff initially agreed to a settlement. However, within a few minutes, plaintiffs changed their mind. So Sean was like, "Hey, I can pay you half now. I can do this." And then she says, no. So she's changed her mind on settling this case and then just went straight to court. On or about June 28th, 2021, plaintiff changed the terms of their settlement offer by increasing the amount to blank plus dollars and demanded payment or else. Defendant Sean then contacted Wes Ellington with Arizona Registrar of Contractors and informed him defendant Sean was being extorted and needed advice. She wanted $10,000 plus $10,000 on top of the entire amount that it cost to do the project. She wanted that $34,000, and then she was like, "And I also spent an extra $10,000 repairing all this stuff." And so Sean is saying she's extorting me. So let's see what else happens. On June 30th, 2021, Owens demanded defendant Sean pay blank dollars tomorrow, or she will file harassment charges and 2 other felony crimes. Defendant Sean then sent an email to Wes Ellington, the Arizona Registrar of Contractor Investigators, asking for advice. Defendant Sean then had communicated with client on July 7th, and Owens stated she wanted blank dollars in 2 payments, and the defendant responded in a text message, "We can find resolution after ROC investigation." On Friday, August 13th, 2021, the day of the Registrar of Contractors inspection, plaintiff sent defendant Sean a text message stating, "Hello, there was an incident here in the middle of the night, and we are suspicious of Lone Cactus LLC's involvement in it. We are looking into filing a police report this morning. Again, you never responded to my messages from yesterday to acknowledge your receipt, which is yet another indication in your role in last night's events. She always says, if you don't respond, I'm going to take that as a yes. So Sean didn't respond to her or reply to her or acknowledge that he got the message. So she's like, I guess that means you did it. Like, no, that's not how things work at all. That's not how any of this works. The police will be standing by to arrest you should you choose to. Wait, okay, which is okay. But you and your crew are not welcome on or near our property at any point in time. The police will be standing by to arrest you should you choose to. Please let me know if you plan to have a courier deliver a check or do a bank transfer in the amount of blank, which must be received by the end of the day on Monday. If I do not hear back from you by 10 a.m. today, a lawsuit will be filed today. If I don't hear back from you tonight. On Friday, August 13th, 2021, Blank, an Arizona registrar of construction investigator, called defendant Sean and said inspection is called off and the case is closed due to the plaintiff not allowing access. Interesting. She wouldn't let the inspector come and look at anything. All of the work performed at plaintiff's residence was performed in a workmanlike manner and met any existing building codes. The work was up to industry standards, yet plaintiff continues to harass the defendants and their workers. Plaintiffs told defendant Sean not to return to the property, would not give ROC inspector access to the property, and even tried to prevent the defendant from removing their machinery from the property. Wherefore, plaintiff's motion for summary judgment should be denied. Respectfully submitted the 7th day of February 2022. Signed, the attorney for Sean and Lone Cactus Construction. Copies sent where they are supposed to. So that's interesting. That's a little bit of stuff. Notice none of those messages were included in the 121 exhibits. But this still doesn't wrap everything up. Okay, and then here we have on February 11th, 2022, in Owens v. Lone Cactus Construction and Sean, Superior Court of Arizona, Maricopa County, minute entry. The court has again received and reviewed a plaintiff's motion to compel and for sanctions, filed February 4, 2022. This appears to be yet another disclosure of discovery dispute in this case. So apparently there has been multiple times of this from the plaintiff, and judge seems a little exhausted by the repetitiveness of certain things that keep happening. As the court has previously informed plaintiff multiple times via minute entry filed December 14th, 2021. In the first instance, this court requires strict compliance with the Arizona Rules of Civil Procedures 26D regarding discovery and disclosure disputes. Therefore, it is ordered denying the motion to compel and for sanctions with prejudice. With prejudice, do not file another motion to compel or for sanctions. You are not allowed to file this anymore, the judge says. It is further ordered that plaintiffs shall file no further motions to compel and for sanctions without leave of court, which means with permission from the court. You are not to file this again without permission from me. Should plaintiff obey this order, the court will set an order to show cause hearing to discuss appropriate sanctions to be issued to the plaintiffs. So Owens and her mother are going to get sanctions if they don't stop doing this nonsense. Pursuant to Arizona Rules of Civil Procedure 37B. So knock it off with these motions to compel and for sanctions. The judge has told you no. Now you're not even allowed to file it again. And if you do, you're looking at sanctions yourself. So the Honorable Judge Sarah Agnew is done. She is done with Jan and Laura's nonsense. But while the judge is tired of Owen's nonsense, she did end up ruling in favor of Owens and Jan. And she put in a judgment that was entered in favor of them in March of 2023. So this is something that I think was going on around the same time. She had cases going on during the Greg Gillespie thing, like the first part of the Gillespie thing. She had this one going on as well. And in the last part of the Gillespie thing, she had the Clayton stuff going on as well. So she's had overlapping lawsuits, in these last several years. I don't know what that judgment was. I do not have that paperwork. This is all off of the Justice for Clayton wiki page. I will link that in the description box of this video. So if you want to go look at it, we've gone over everything under the tab of Lone Cactus Construction, the Uber, and the Clayton Eckert stuff. We've covered pretty much the whole wiki page now. But if I do get any more paperwork on this particular thing, I of course will make a video and update y'all. But that is going to be it for this case review. Hit the like button, subscribe, turn those notification bells on for more videos in the future. Bye.